Hello, Solicitor Kudus here. Let's look at some of the questions that have come through. Now, can an overstayer that already got married to an EU citizen who is settled in the UK apply for a family permit of an EU member or a UK spouse visa? Now, if you are an overstayer and you managed to get married to an EU citizen who is present and settled in the UK, if the marriage happened after the 1st of July 2021, then you would not be able to apply as a family member of an EU citizen. However, you will be able to apply as a family member of someone who is settled and present in the UK. Now, there is a specific advantage with EU citizens. EU citizens in the UK, whether they have the pre-settled status, which is the temporary leave to remain, or they have the settled status, which is the equivalent of the indefinite leave to remain, it doesn't really make any difference. So if you're married to an EU citizen who is in the UK with either a settled status or a pre-settled status, you can apply for a spouse visa if you meet the requirements for a spouse visa. Now, since you are an overstayer, clearly you do not meet the requirements of a spouse visa. So you would be able to apply like any other person would be applying under the family life to live with a British citizen. So can an overstayer who is in a relationship and has a child with settled status partner be granted indefinite leave to remain or BRP due to the child? Now, I think what you're trying to ask here is if you have a child as an overstayer with an EU settled person, would you be able to stay in the UK on the basis of a child? So what I would say is I would answer it on both scenarios. So if you are married or in a relationship as an overstayer with a settled person or a person with the pre-settled status, and if there is a child in the relationship, again, the same principle in the general UK immigration law would apply. So you would be able to apply under the family life rules, under Article 8, to be able to live with your partner, of which the child would come in. So again, the child would come in and the assessment under Section 55 of the 2009 Act, which is the best interest of the child, would come into play, and all the other rules of Article 8. So yes, you would be able to live with your partner if you're still in a relationship, and the fact that you have a child with the EU citizen is going to be an advantage, but it's not going to be exclusively because of the child. However, if you're not in a relationship, again, the same rule in the general immigration law would apply. If you have access to this child and you're committed as a parent, then you'll be able to apply under the parent route. The next question then is, can a skilled worker visa migrant switch to a settled status if your child has settled status? Now, obviously, you cannot switch to a settled status if you are a skilled worker migrant. Anyone can switch to a family life visa. Anyone can switch to a protection visa, which means under the Refugee Convention or under the humanitarian protection. So anyone can do that. Can you sponsor someone to visit you in the UK if you are on a 2.5 year leave to remain? Now, the question of visitor's visa is not so important. Let me make this point, the benefit of those who are interested in sponsoring or inviting others to visit the UK. What your bank statements, your accommodation, your properties, all what you have in the UK is not as important as what the visitor has got back home in terms of justifying that the visitor is a genuine visitor and would return to his or her home country after the visit. So if you're inviting or sponsoring someone to visit the UK, actually you're not sponsoring someone to visit the UK, because a visitor doesn't need a sponsor to come to the UK on a visit visa. What the entry clearance officers would be assessing would be the ties that this visitor has got back home. So we are talking of cultural, economic, and other ties that a visitor may have back home, which, as far as entry clearance officer is concerned, would be some sort of a pull factor for the visitor to go back home after the visit. So if you have no employment, you have no assets, you have no family, you are of working age, your chances of getting a visitor's visa would be really, really slim, no matter how much the sponsor in the UK will present in terms of bank statements and guarantees and properties and all that. So that is why those with good assets and good connections back home, including family members, assumption by the entry clearance officer is that such a visitor would not afford to abandon all these things that they have back home, all these ties, to stay in the UK. So they would most likely grant them the visitor's visa. The same with those of a certain age. The presumption is they are not coming to the UK to seek employment and a better life. They probably have had their lives and they are just coming to the UK for a visit and go back. And that is why you find older people get visas granted without much difficulties. If you have questions that you're sending through, what are the options that I have? You would not get a response because it's very difficult to give a response on what your options would be without knowing your particular circumstances. So the best thing to do is to contact my office, book an appointment for consultation. That way, you'll get a customized package of advice after having assessed your particular set of circumstances.